commission itself in
One matter already pending on the. Let this matter be also heard along with petition civil number 1290/2021. No,
which is that matter, my lord?
there is one matter pending.
Acha, I'm not aware of it.
That is disposed of. That
No,
was,
that is disposed of, my lord. 1290 is disposed of with direction saying that that was on a different issue. That is not on the expenditure by political parties as such. That was only on one part of this problem. That is,
there is one more matter, I think, Mr. Padre has probably, we don't know.
That is on freebies.
Yeah. No, my lord. There is separate petition in 2025 and the,
On election spending.
not per se, but it's a restriction.
that is on freebies.
No, not freebies.
Not freebies. Yes.
There is one matter, if I remember.
Yes,
correctly,
my lord.
On the,
Lordship issue notice in,
on defining the
two, yes.
maximum,
yes.
maximum limit.
I will give the rate number, my lord. I will give the rate number.
Oh, this is, anyways, if you notice, then we'll see.
I think it's in September.
I think your lordship may just issue notice because
Yes.
that other matter is not really pending. Returnable on some date.
Yes, we'll give it.
I am applying.
Of course.
Yes. My lord, the false cases, my lord, the biggest barrier, my lord, to achieve the goals, my lord. The false case.
Now, this issue, people will, you have to be ready, people will criticize us, saying that this is another way of dragging the mob. They will accuse us of doing this. But if you, why one should be afraid of gagging? If you are a responsible citizen, then you will own the responsibility and say that, yes, what I'm saying is correct. Because people make abusive language, they try to defame people, and then they disappear from the scene because they know nothing can be done. So some check and balance is required. The way it is being
What
abused.
is happening, my lord? I travel 100 to 120 districts every year, my lord. Every Saturday, Sunday, entire summer vacation,
At least this was suggestion that on police station, railway station, display board, that if you
Yes, yes.
make false
My lord,
complaint, then
what was the issue in this UGC issue? उनका ये कहना था कि कॉलेज में आपके ऐसे फॉल्स केस होंगे. अगर वहीं एडमिन जो ब्लॉक है वहीं पे एक बोर्ड लगा दिया जाए कि दिस इज फॉल्स केस सेक्शन सो एंड सो, इम्प्रिजनमेंट सो एंड सो, false charges section so and so, this is, well, it will control the fake cases. Lordships are overburdened not due to the real cases, my lord. Lordships are burdened due to the fake cases,
exactly.
particularly the district judiciary, my lord. Particularly, I am giving 2-3 examples, my lord.
By the time
झगड़ा होता है खेत का और मुकदमा लगता है SC/ST एक्ट का. पति पत्नी में झगड़ा होता है और नंदन नंदोई सास ससुर सबको उठा के डाल दे, सबके खिलाफ शिकायत हो जाती है. क्यों? क्योंकि फर्जी शिकायत करना अपराध नहीं. झगड़ा होता है किसी और बात का और लग जाता है मेरा रेप का केस. अभी इसी हफ्ते क्या हुआ है, मध्य प्रदेश में एक बड़े स्वामी जी की कथा शुरू होनी थी, वहां एक नेताजी को आना था, नेताजी नहीं पहुंचे. स्वामी जी ने मन से बोल दिया, नेताजी ज्यादा बिजी हो गए होंगे इसलिए नहीं आ पाए. वो बात बुरी लग गई, सीधे रेप का केस लगा दिया. जो स्वामी जी एक हफ्ते कथा करने वाले थे अंडरग्राउंड बाहर घूम रहे हो, अंडरग्राउंड बेचारे घूम रहे, वो बेल के लिए घूम रहे. तो मतलब ईमानदार, मतलब प्लीज अप्रिशिएट, मतलब ईमानदार लोग डर डर के रह रहे हैं क्योंकि एक फेक केस से बाहर आने में विष्णु तिवारी को 20 साल लग गया, नंबी नारायण को 15 साल लग गए. मतलब पूरा हमारा जो गांव का जो फैब्रिक है मतलब ना पूरा डिस्टर्ब हो रखा है. मैं प्रयाग का रहने वाला हूं, मतलब लगभग हर 2 महीने में गांव जाता हूं. वहां जाके एक ही बात समझ में आती है कि गांव में जो झगड़ा हो रहा है, एक दबंग दूसरे जमीन पे कब्जा करता है, वो गांव वाला जो गरीब बेचारा अपना लाठी लेकर खड़ा होता है, वो दबंग किसी के उसके खिलाफ केस करा देता है. फर्जी ये केस, फर्जी वो केस, रेप का केस, छेड़छाड़ का केस, अपने घर की महिलाओं को आगे कर दिया. ये हो रहा है मतलब. तो जमीन का विवाद तो बाद में गया, मतलब केस चलना था एक सिविल का केस, उसके बदले 2 केस क्रिमिनल का और शुरू हो जाते हैं। दिस इज द रियलिटी माय लॉर्ड। I filed many petitions, my lord. I am saying that this is the most important petition, my lord, to ensure the right to life, liberty and dignity. My lord, just give me 2 minutes.
We need to create a very informed society, a lot of sensitization of the people to understand the value of if you are so a person, they are always thinking of their fundamental rights. They need to learn about their neighborhood fundamental rights also. So unless we cultivate that culture,
Just see, my lord, the prayer. Please see my prayer.
That
It's not adversarial petition, my lord.
foundational principle of fraternity, unless we cultivate.
My lord, just see my prayers. This is not adversarial petition. I am only saying, मतलब थाने पे अगर कोई आ रहा है FIR लिखवाने, अगर ये रिस्पॉन्सिबिलिटी हो जाए कि एक बार उसको ये कह दिया जाए कि जो कह रहे हैं वो ठीक है ना, क्योंकि ध्यान रखना ये सेक्शंस हैं जो झूठे केस के हैं। I am giving another example, my lord. Just see my affidavit at page number 24. So for filing this PIL, I have given 11 undertaking, right, my lord? Then I verified that all the 11 things is right. अगर इसी में एक पैरा my lord और जुड़ जाए कि मुझे ये भी पता है कि फॉल्स एफिडेविट फाइल करना अपराध है, मैं बिल्कुल नहीं करूंगा, कोई नहीं करेगा, इतना इफेक्ट होगा। अभी लोग फॉल्स एफिडेविट फाइल कर सकते हैं, लेकिन अगर उसी में BNS का प्रोविजन लिखा हो, उसमें पनिशमेंट लिखा हो, मतलब नहीं होगा। And there is a section, my lord, this chapter 14, my lord, this is section 14.
So further problem will arise, and problem is actually that when these false complaints are lodged, the de facto complainant does not know even that he or she has lodged a complaint. It is someone else who gets some impression, blank signatures, take him to the hospital, to the police stations and other places. The poor fellow doesn't know even that I am being exploited by another affluent person.
My lord,
This is how it happens. Huh? A case, the wife coming to us, telling that so and so political leader is not involved in the murder of my husband. Now this statement, where is the necessity for her to make a statement before us? Unless either she on the gunpoint or on the PowerPoint or power plus point.
the money point.
Money point.
Yes. My lord, just see the
What kind of guidelines we can?
obliged, my lord, highly obliged. Returnable in 4 weeks, my lord? Returnable in 4
yes.
weeks. Obliged, my lord.
May it please your lordships. My lords, in all fairness, at first blush, my lords, my view was that the jurisdictional high court should be approached.
Absolutely.
However, my lords, on a deeper consideration, on some research, my lords, it transpired that there are several states where actually this issue is a pan-India issue, where in fact the ex-cadre posts, which are fixed as per the my lords, cadre fixation regulations, which is one is
Don't worry about the pan India, you go only take care of your own state. And go to your.
Well, it's only because the issue is of an endemic nature. That is why. It is only that my lords, transpired insofar as the pan-India issue is concerned. And it is an issue. Even the letter which your lordship will see by the central government, where this prior concurrence is mandatory, is not being adhered to. With the result that 1:1 has become, in this particular state, that 1:1, from 7 it became 13. Now there is attempt to make it even more. And there are states, states like Bihar, there are states like,
Not the politicians never do this kind of mistake. It's all bureaucrats that they have destroyed their own culture of all India services. Only for plum posting, only to avoid inquiries and investigations against them, only to hide their illicit money after retirement, and only to get post-retirement assignment.
your lordship is right. My lords, insofar as your lordship used
It's
the
all
term,
their handiwork.
yes, because your lordship used the term fraternity, there's a constitutional setup which regulates this. There's a statutory regulation which is
They have a very, very strong
lordship.
uh,
Because
the system, how to scratch each other's back.
the central government will not say anything because there is something like a constitutional morality where in case the central government says anything, there'll be the issues of center and state.
Go to High Court, try your luck.
Because I respectfully submitted the picture that it is an pan-India issue. However, as your lordship.
You see no reason.
Because may kindly give me liberty to do that.
This one is according to dismiss. The petitioner, if so advised, may approach the jurisdiction of High Court.
Very well. And my lords, in case the occasion arises, maybe the matter comes here, because it's a matter which your lordships feel
Come, we'll see.
does require examination.
One different states.
Lordship, please. Grateful.
May it please your lordships. Tuning an interim order of the tribunal. Your lordship, on a video, both the district mining officer and the police find no truth. In fact, report that the video. They are asked, action is directed to be taken against the SHOs. I can show the facts, your lordship.
20 this year, 24.
One second. May I? Your lordship, may I show the paras before that, your lordship? Because it shows,
18 was the day.
your lordship, may I, with your lordship's permission?
February. What happened on 18th February?
18th February, your lordship, the state took time.
So you
And that
must
is
have
your-
also.
Now it's gone
We
to
hope
March.
that you have also
Your
entered.
lordship,
clearance.
but see the report of the state.
Yes.
Your lordship, I'll just show a few paragraphs. May I see para 9 first? Who is the complainant? Person against whom there is FIR even on the 2nd of January for illegal trucks. This is the complainant who is again and again producing unauthenticated, unclear videos that is recorded in para 9. Lordship, may I see para 9, page 3.
At least somebody is mustering courage to record videography of your trucks.
Your lordship, videography, your lordship, it is seen. Your lordship, we have seen the video clip. This is the tribunal's own finding.
Please go to tribunal. This is only an.
Your lordship, may ask them. There is a DLT.
Why should we
Your
ask?
lordship, may I only submit?
We don't
over-
consider you such an important person that we should call.
No,
them.
your lordship, may I just say, your lordship, overreach, a fact finding must be done by someone. They can't say everybody is wrong and unauthenticated video is correct. Now, this honorable, the tribunal itself has appointed something called district level task forces. They don't avert to that. They just say that both the district mining officer as well as the SHO are entirely have some lacuna. So we, on the basis, Your Lordship, I have to pay my dead rent, my license is not cancelled. I am just constrained from mining authorities. So Your Lordship, they can refer to the district level task force. They can get a fact-finding report. And basis on that, whatever action has been taken for me for, Your Lordship, operating against GRAP or operating, Your Lordship may see, para 9, we have seen the videos, that's the earlier order. And we find that the video clips do not clearly record mining activity. That is para 9, Your Lordship. Thereafter, Your Lordship, there is an action taken report by the, and Your Lordship may just see one thing on page 7. They were, in fact, sorry, page 6.
Yes.
Page 6, Your Lordship, 4, Roman 4. That is the night, apparently, that video was recorded. That the Assistant Police Commissioner Lori directed the Chowki in charge to visit the said site, that upon the said instructions, the Chowki in charge immediately reached on the said site at 10:37 p.m. Upon physical inspection of the site, no illegal mining activity, machinery, or ongoing excavation was found at that time. Now, so there must be a fact to overturn this. It cannot be on basis on unauthenticated, unclear videos. Similarly, the DMO, Your Lordship, records and FIRs are all registered against the so-called complainant, and the trucks seized on that night are of the complainant. R8 here. It is his trucks, not mine. Yes, I'm coming to that, Your Lordship. I am not going to, I cannot, Your Lordship, escape. I'm coming to that, Your Lordship.
No coming or no coming, you have to, we are not entertaining this.
Your Lordship, may I just come to para 20 and I'll read it, Your
Para
Lordship.
20, why to waste your time and your
Yes,
time is
Your
more
Lordship.
important than our time.
Now, Your Lordship, they say in reverse, we have seen the video clips recorded in pen drive and we find the video clips recorded on 2/1/26 at so-and-so, so-and-so, and so-and-so. Same time that the police is there. Show illegal mining of the sand from the river channel by use of JCB. Now, Your Lordship, they themselves say these video clips are unclear.
Business partners, sir, the police people, the district collector, the tahsildar, the local people, all are your.
Your Lordship, which is why there is a DLTF. There is a district level task force meant,
धंधा करते हो तो
Your Lordship, district level task force may find against me. And Your Lordship, thereafter, para 23 and 24 may be seen that in their response dated 21/26, the geo coordinates of the site upon verification was found that only loading, no excavation was being carried out. Para 24, these observations made by the DMO are patently wrong. That is based on an unauthenticated by an interested party. Now, Lordship, I'm only saying that they can make a fact finding, but it must be done. Govardhan also says, Your Lordship, we must file a reply. So, Your Lordship may ask them to direct the DLTF and Your Lordship may remand it back. We will submit all the evidence, they can take their call. But it cannot be, Your Lordship, based only on an unauthenticated, unclear, admittedly unclear video, where all the authorities are saying otherwise. Your Lordship, it must be based on some facts. And now they have a mechanism called the district level task force based on their own decision.
We see
So
no
let-
ground to hard lunch in the council for the plan at a conceivable length. We see no ground to entertain this appeal against an self-seeking interlocutory order when the matter is still pending consideration before the National Green Tribunal. The appellant, so advised, may move an appropriate application or seek redressal of its grievances before the tribunal.
I'm obliged.
I am in
30.
32 also 40.
Yes, Mr. Attorney, what is to be done?
No, every tribal is problem is likely to arise. Then that's why the judgment now opened up a certain set of considerations beyond that easy calculation. So if somebody is retiring on 9th of March, 15th of March, things like that, but they were all appointed under Tribunal Reforms Act. The tenure was fixed particular period, 4 years. So
years,
to
3 years.
extend what was probably extended persons were appointed.
Whatever now, unfortunately, the uncertainty which is now created, that has to be resolved.
No, that is true. But then whether to extend them to them, the benefit given to those who are appointed prior to the Tribunal Reforms Act is one question. Because all those cases were resolved by this court saying, if they're appointed prior,
Attorney, paragraph 155, recommended before, appointed after the act.
that's
That
right.
is the protection.
That's right. Therefore, those appointed later, but then the election took place prior to the Tribunal Reforms Act,
These-
they will be governed by the earlier terms and conditions of service. But to extend it,
That is
to extend
exactly
it
the-
universally to those who are appointed the Tribunal Reforms Act,
I don't think they are asking for that. They are asking for those cases.
so there are people who can have additional charges
Sir,
till a
sir,
lot
as
is
of
passed
now
the
we are-
further order.
Mr. Attorney, as of now, we are not inclined and we will not, uh, 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 there is no reason for us to extend the term straight for 1 year or so.
That's right.
But it is, these tribunals are your creation. Now they have become your own headache. And a headache for you, a liability on us.
It is.
It's a liability on us. The kind of, barring 1 or 2 tribunals, the kind of orders are coming, the way the tribunals are functioning, and particularly the challenges which are coming before us. thanks to the legislative regime, we have led to creating a no man land. They are not accountable to judiciary, they are not accountable to anyone on the earth. That kind of system, at least I am not going to approve it. But the reality is that today matters are pending, the hearings are taking place. How we can close down them unless we have an alternative mechanism. So
What I will do is, in fact, there are different tribunals, some different days of retirement.
one
coming.
tribunal application I was
And then
examining.
different tribunals. So if
In one of the tribunal, I was just in the night when I was examining, I found that if the chairperson is not allowed to continue, a technical member will take
That's
over.
right. He will be an additional charge. Somebody will be given additional charge as a chairperson. Till we take a final call on it.
Why
Till we
the-
take a final call. I mean,
Why
to
the
have ad
technical
hoc
member?
orders, to pass ad hoc orders in respect.
Because of our judgment of this court, a technical person cannot pass an order.
Right.
That's
Not a final
true.
order.
But these are the problems created by, because the court did not envisage all these issues. So how do you iron out all the creases by one norm, one principle today? There's a problem we face.
That's why we said, we told you only, about week, 10 days back.
We are looking into that matter. I'm trying to find out how best we can do that. But in the meanwhile, if this kind of individual cases come up, and then we pass ad hoc orders on that, it's going to be problematic.
No, we are not giving effect to any judgment or anything. We are only wanting there should be at least no functional crisis for the time being.
I understand that. We will not then take it up immediately after the holy holidays. I'll come back how to find out some intermediate solution before we come under the larger questions. Because I'm given a lot of information about various tribunals.
Notice when so and so accept notice, your assisting lawyer attorney accept notice. Post these applications along with all other connected matters on so and so date. On so and so date. Meanwhile, if the term expires, comma, the existing chairperson stroke members may be allowed to continue as an interim measure till further order.
That's
Not item.
That's 33 is a petition. Your lordship's only said applications. 33 is a fresh writ petition. That's same.
we
For filing an application, we have filed a fresh writ petition.
That's it.
In your lordship's order.
In the petition.
Application stroke writ petition.
Item
I don't mind the
53
entire
also, my lord.
matter being reheard.
Not item 53, my lord, the same orders. I'm obliged. 53.
There's 32 and 53 only, I think.
33 also. 33 is a fresh.
We don't know.
That's okay. You might not. It's a
In
fresh.
one of the tribunal, which is with the, in a very short duration has acquired very immense importance going by the economy of the country. My feedback is, and I'm quite sure my feedback is not imaginary. The technical members are not writing a single judgment, not a single judgment. They are either insisting the judicial member that you write for us also in my name. I know one of the audacity of one of the technical member, and I'm waiting for, I will sack that
Your
member,
lordship,
no, judicial order. Telling the judicial member that you write in my name, otherwise I will not sign your judgments. Or outsourcing the.
Oh, I see.
This is something which was completely unheard in judicial system. So I'm really perturbed about these things, that what the mess we have created. In the name of creating only with an anxiety that High Court should not exercise constitutional power. And in that over anxiety, we have created a situation completely damaging the judicial system, quasi-judicial system. And look at Mr. Attorney, you don't now allow the High Court judges for 15 years, 20-year tenure. They don't now learn environmental law. They don't learn commercial law. They don't learn company law. They don't learn bankruptcy law. And suddenly when they come for 4, how many are lucky like my two brothers, or I was fortunate enough to have almost 80-year tenure. They come for 4 years, then you want them to become expert of everything. Somebody will have to.
In the early 80s, when England was talking about tribalization in a big way, then of course they learned.
What we are only requesting is that some holistic view will have to be taken. maybe that you completely need to introduce a complete new mechanism for the tribunal. The tribunals are permitted under the constitution, no difficulty. But the way these have been constituted, the manner they are allowed to operate, the manner in which they are completely unaccountable, that is not probably in the interest of, in the national interest.
I mean, this question has been addressed at the very highest level. In fact, I'm having almost on a daily basis. So you'll have to give me a little time to address this interim issues.
We'll
The
take
larger
it after
questions are
4
being,
weeks.
certainly, yes, yes.
3-4 weeks, meanwhile, please examine what can be done.
32, 33, and 53.
All
I'm obliged.
matters.
Great.
I'm obliged.
Item 34.
Admittedly, Manos, in the base case, he has been acquitted. We cannot shy away.
Now
from
that
the
has
fact.
been,
Yes. There is the issue, Manos, because that forms the fulcrum of the prosecution.
the very foundation, the very basis. goes.
Yes.
Only thing is that against the base case, there is an appeal against.
There is an appeal pending though, Manos.
In future, if the base case,
There is an appeal
if
pending.
that's what we are
Yes.
saying, in favor of your notice, that since there's an appeal,
Yes.
in the event the appeal is
Yes.
allowed and the conviction restored, this prosecution may also
It
get
creates
some
a
light.
paradox kind of a situation, Manos. Both ways, in fact. If the appeal is dismissed and in the meantime, if he is convicted, then
No, this appeal or this notice can never be heard before if the
That-
appeal is
yes,
allowed.
it's pending before the
If
Honorable
the
High
appeal
Court.
is dismissed, but if the appeal is allowed and the conviction in the base case is restored,
Yes.
then you have a case to argue.
Then we have, yes.
And in that case, you can always register a press case. on
Fresh
that.
case.
Yes.
That liberty.
Mm.
That
Liberty
liberty
taken.
perhaps can
We
be,
have,
that liberty perhaps can be
liberty.
given, yes.
so we have heard lunch, Shri Ishwan Thakur lunch, advocate and additional advocate general for the state of UP. In view of the fact that the first respondent has earned acquittal in criminal appeal number 5295, stroke 2023. By the Delhi High Court, where judgment dated 29th July 2024. No, not this one, sorry. And by the, what is the date of the judgment of the Delhi High Court?
Delhi High Court is 3/7. No. Delhi High Court. Yes, Manoj. No. Yes. Yes, that's Manoj.
Page 6.
That's 3/7/2019. I'm sorry, page I.
That in view of the acquittal earned by the first respondent before Delhi High Court in
719.
Number 1 was acquitted by this Sessions Court, while judgment
Case
dated
crime
3rd July,
number 589 of.
3rd July 2019,
Case
in
crime.
case crime number 589 of
Yeah.
2005, comma, the view taken by the High Court in the impugned judgment, whereby the postings under the Gangsters Act, UP Gangsters Act, so and so have been placed, comma, is the correct statement of law. And it does not warrant any interference by this court. Full stop. However, since the criminal appeal number 1178 of 2019 against the above stated judgment of acquittal dated 3rd July 2019,
Yes.
comma, is pending before the High Court of Delhi, comma, the impugned judgment of the High Court is subject to the outcome of those proceedings.
I'm so grateful. And our appeal as well, Manoj.
In other words, if the acquittal of the respondent, first respondent is reversed, comma, the law will take its own course, including the enforcement of provisions of the UP is one so gangster.
I'm grateful. I'm grateful.
First, actually,
Well, this is a mod.
I entered.
Well, yes, plus this is a modification application. These petitions are arising from, there are two petitions arising from cross FIRs. My lords had disposed
Kind
of and
you are a
remanded back to the
threat.
High Court.
You are a threat to people, including this victim. You don't require any protection.
Because I was given protection by this honorable court on in the initial date 19th of July itself, my lords. I am just seeking because we are being remanded back from the High Court.
Because this
for fresh
victim has been granted protection by us, the lady, that does not mean that you also deserve.
Well, the lady's FIR was the first FIR. She files an FIR saying that I was your employee, I was sexually harassed. 2 months later, to pressurize her, he files a defamation suit. So therefore, your lordship and your lordship are considering quashing petitions against both of us. He also filed a quashing of my FIR and I filed a cross quashing. The High Court rejected his dismissed his quashing petition without adverting to my quashing petition at all. And in the process also dismissed my quashing. Therefore, when I...
That's why we remanded the matter.
Yes. Therefore, your lordship remanded the matter, giving me protection and saying that quay him, there should be no protection. Let the trial continue. If he's innocent, he'll be...
But he feels threatened by you.
Since we are remanded back on a fresh notice,
A lady employee.
we are remanded back to the High Court on a fresh note. Everything has to be done on a fresh.
What
So
this
we
poor
need
young
to be
lady
on the
will
same
do against you? Why are you?
Because, my lords, I was given a interim stay by the High Court also, by this honorable court also. Now that when you are remanded back,
No, but the point is, we only remanded it. We have not set aside that order.
no, that's correct, my lords. But my lords have noted this is for a fresh consideration. So since this is for fresh consideration and with the same,
Go and apply to the High Court. What is the problem where the matter is pending?
then my lords may say so that we'll apply to the High Court. They'll consider it.
We will request the High Court to reconsider.
Please, my lords.
The instant application has been filed seeking modification of the order dated 19 December 2025. Passed by us in criminal appeal, passed by this court in criminal appeal number 5598 stroke 5599 of 2025. The applicant seeks interim protection against arrest through this application. Understood. A perusal of the subject judgment order will show that we have remanded the case to the High Court. The applicant petitioner is so advised may approach the High Court for the grant of necessary.
Please.
For the grant of the necessary relief. PMA is disposed of with legal performance.
Would the court clarify that no opinion on merits has been expressed by my lords in the matter?
But that we have not expressed any opinion on merits.
Deeply obliged. Please, great.
My lords, I'm appearing for the petitioner, my lords. My lords, I'm seeking short adjournment as my colleague's grandmother has just passed an hour ago, my lords. So, my lords, kindly adjourn this matter,
All right, all right.
my lords.
Seven, my lords, may be tagged with this other petition at page 205 is the order.
No pleading of repugnancy in your petition.
Not in mine, my lords. I had taken this ground earlier, but that's now available, my lords. There are several other grounds, my lords, which I am afflicted with. In fact, one of the provisions is this.
Trial is going on.
Well, it's not completely independent of that. In fact, my 482 in the gangsters is also rejected. My SLP is
That's
also
what we are
pending.
saying.
Correct. Something. So this is.
And you have challenged that by way of an SLP.
Correct. So that's been filed, in fact, registered.
Something to add in this matter, not against your case, particular case. Give the compilation. Actually, this is a challenge to the validity of the UP Gangsters Act. Challenging the particular act. Earlier, there was a writ petition filed before this Honorable Court. It came up before the three judges bench. I am giving that order. That is the first order copy.
Can I have a copy of
Yes,
that?
I'll give the copies.
Please.
I'm not saying something against you.
No, no,
just
that's fine,
wait,
that's fine.
just let me
absolutely.
on facts.
When you're there, I'm absolutely assured of
Yes.
greatest
So
fairness.
first that three judges bench, they dismissed by saying that we can't entertain 32 petition. That's first one. Then thereafter, incidentally, in another matter before the Uttar Pradesh High Court, Allahabad High Court, at page number 5 in para 6, they observed that it is redundant. At page number 5 in para 6. Then thereafter, one more SLP came.
Para 6 say this court finds that the provision of section 2 is regarding punishment for committing the offence of organized crime, like this one says one. Therefore, with the incorporation of tentatively that provision of UP gangster have become redundant. Oh God.
And
We
matter
will never
was
learn in life.
Yes. And
Yes,
there
I
is-
think in the oath itself, we have taken an oath not to learn.
Yes. And that is the second one. Thereafter, one more SLP came before this Honorable Court, where this Honorable Court permitted the party to file some appropriate petition or impeding application and raise that ground before the High Court where the issue is pending in para 2. At page number 6, para 2 is bottom. We grant liberty, then para 7. We grant liberty to the petitioners to intervene in such petition and support the point which has been noted in paragraph 6 of the said order. That is the third order from this Honorable Court.
This para 2, order that is 7 July 25, the same order which you.
Same order, referring to same order. Then thereafter, there is one more 32 petition, which is now pending, and the division benches, the two judges bench that is now considering, that is the order passed in the, before this court.
Now, this matter, Malot, is actually.
One second, let me complete. I'm not saying anything. So now,
How can this happen? Then all Makoka, everything will go.
So this will have to be tested. I'm sorry.
See, if this argument is taken to its logical conclusion, that because of 111 in BNS, the organized crime provisions in the state laws will suffer from the principle of repugnancy,
Correct.
then according to you, all the provisions of organized crime legislations in different states will be rendered unconstitutional.
Well, it's the exact same question that the query that your lordships are putting to me is actually under consideration. Please have my petition at 205 for a moment.
That we've read.
So the same question is actually pending before that honorable court. It's part heard, it's listed, Malot, in the next week or so.
What about
Top of the board.
section 26
Now,
of the
Malot,
general clauses
on the
act?
principle of MA Tulok, etc., the old principle, Malots, of repugnancy, etc., and also, Malots, if there is a new law which has been introduced with the central law, that will, Malots, make the state law ineffective if it covers that.
What
So
about
all of these are considerations which are actually under consideration by another bench, Malots. So all I'm asking today is this, that the matter, Malots, and that too it's parted.
let me
Please have
complete.
205 for a moment, Malots. The learned additional solicitor
me-
general started with that.
No, I want to
Because-
complete, Mr. Alam,
Correct,
I want to
yes.
complete, let me complete.
No,
So,
his
now-
compilation includes 205.
205.
205.
So
Then
therefore,
the-
if your lordship see the
The
top
issue
of that.
which,
Particular subject.
the issue what they have raised. Now, which issue which they have raised with regard to the repugnancy, now the effect would be, I have given in the first page, chart about the 4 or 5 legislations.
Additional Solicitor General, we have seen that is
Yes,
what
yes.
is troubling us.
Therefore,
Because in our understanding, if that general law
yes,
making organized crime or incorporation of organized crime,
yes.
can it be treated as a repugnancy at all in face of section 26 of General Clauses Act?
In the event,
this-
in
this
the
is
event
what
it is.
Legislations
In the
create
event-
separate offences.
Correct. Well,
They
This
must
Honorable Court is inclined to consider it,
Well,
let
this
all
is
the matters
exactly
be
the
called
question.
here.
This is the same defense which is already taken by them before the other bench.
Let all the matters be
Now
called
the
and
same,
considered by the
all
three
I'm
judges.
asking
There's no
today is for
problem
a,
because
This-
all,
this
all I'm
system-
asking today,
The system of dividing Supreme Court in benches is very disturbing for
Very
me.
disturbing.
The,
I'm sorry, Manoj?
the system of dividing Supreme Court into benches And that too, of course, it's about, the things don't take place in simpler manner. There are some
So, Malots, that's.
challenges with the institution
If we
itself. has
implement all
become-
the matters.
That is,
good
that
for
is
the
an area,
party.
that is an
Let
area
all
where
matters
Malots,
come before
we
the-
actually don't have any say. So, Malots,
Good for the party.
Let
my
all the
concern-
matters, let
my
all the
con-
matters come before three.
my
judges.
concern,
But it
Malots,
should remain
no,
certain.
Malots, this is unfair of my learned friend, Malots. This is very unfair of my learned
Bench
friend.
to bench we differ and therefore.
Yes.
So, Malots, this is unfair of my learned friend.
You see 205.
Correct. So that's my concern,
That's my
Malots.
concern.
Which is why I wanted to
therefore I
point out at
want
the outset, and this last request which has been made is not fair.
I
Malots.
would like to examine it on administrative side, how the things have moved and how.
Correct.
So
this should
quite
all-
disturbing as of now.
That's exactly what
I
I'm
have
saying,
your-
Malots. And I did not want to press anything further beyond that, which is why I pointed this out.
Simply
And-
post it after vacation.
And more than that, one more thing, in these matters, I think union also will have to be heard, because it will have bearing on so many states.
All the states.
Yes, all the states
should
will
be
be
a
affected.
notice to all
Every
the states.
will have to be heard, Malots.
Karnataka,
Correct, correct.
Odisha.
And there has been,
Karnataka, Odisha,
there has been
Gujarat,
substantial hearing, there has been substantial
Maharashtra.
hearing in this matter.
Not less
It's
than.
not
10
as though this was
states
on the
have
first day.
Organized crime, state legislation.
So let all the matters come before the Supreme Court, you have no
No,
problem.
Malots,
because of earlier-
this is again an unfair statement, Malots, which I object to. Malots, this is a matter which is part heard. Same plea has already been
Yeah,
taken
please.
there. They've argued this also there.
Please don't doubt the powers of the Chief Justice.
Malots, nobody is doubting that power, Malots.
Part
I
of it,
never
not
said
part,
that
how we
Lordships
know.
don't have that power.
We know so many
My
things,
concern
don't-
is this. My
don't-
concern is just this, that
don't
today,
tell me
Malots,
to
the
embarrass
Solicitor
the-
General is standing up and
to
saying
say
that it should
something
all
which
be
can
brought to a
embarrass-
particular bench, Malots.
which
Your
can
Lordships
embarrass
here at
people.
any other bench, here is at Malots, it's not my problem.
Unfortunately,
Only thing is,
we are not
Malots,
getting a fair
Malots, I just saw that it
answer
was a
from some of
buttered
the
matter.
quarters.
Malots, under the circumstances, allow me to withdraw my petition, Malots. I'll go to.
No question of.
Very well,
we're
very
not
well. I'll
permitted
leave.
to withdraw.
I
We're
have-
not permitted to withdraw. I will
Very
have
well,
to
very
hold
well,
a
very well. No problem.
administrative,
I will-
the matter requires a deeper probe.
Very well, Malots. I will argue my petition.
Functioning of the registry of this court.
I will argue my
The
petition.
biggest challenge before me is the registry of this court. So I have to hold a deeper probe into that affair. That how the matters after one bench express opinion, final opinion, how the matters travel to the other benches. What is that mechanism they adopt? So this is bigger, it's a fight every day to day before.
I appreciate it.
It's not one matter.
Your Lordships are right.
You will find some matters where you will be feeling embarrassed.
Lordships are right, Malots. Absolutely right.
That's what happening here.
We've been here long enough, Malots, to see that.
Exactly.
These things. So Lordships may examine that. That's
Despite
correct.
the very stern measures I have taken, you don't know the mechanism I thought I have been able to create, and that will help me in understanding that. But despite that, the things are beyond control.
I understand, Malots. Lordships.
When I was, last week, there was a complaint received by me. I was nearly shocked to find out that what's happening in the registry of this court. There are employees, there are officials who think that they are here for 20 years, 30 years, the judge will go, maximum tenure is good, 8 years. Nowadays, it can't be imagined more than 8 years. So they think that we all are here for transit stay. We will come and go. They are the permanent feature here. And therefore, the things must happen the way they want.
I understand.
That is what bothering me. And if I am not able to bring this reform before I demit the office, then I will be failing in my duties.
Malots, we are all
Yes,
confident. Your Lordships will.
I have.
With your practical groundwork,
So
Malots.
please don't withdraw. You have to service, you have to render a lot of service to us.
No, absolutely.
Don't withdraw.
I have a request to
Not
make.
withdraw.
Larger
May
public.
I have your lordship,
May I?
1 minute.
Malots, I have.
May I have your lordship's leave to make one request?
Oh, the benches.
No, you lots recollect that 17th, 18th, 9 judges bench matter regarding industry. So you are requested to file a submission by 28th. I think if you can, if the AG can be given a little more indulgence, I can file my written submissions immediately after reopening, because I'm going to assist the court.
In which matter, Mr. Chairman?
The industry, definition of industry.
Industry. Oh, no, please, but.
The submission to file before 28th, okay, since
By opening,
that's right. So I can file it on 9th by opening.
by opening, then we'll extend this date for everyone,
Very well.
for both sides. Let it be by opening, because date we will not now reach.
No, date is not to be changed.
But I'm not going to reschedule the matter. because
Certainly
it
not,
will
certainly not. We are not asking for a
completely-
change in the
it will
date.
collapse.
I'm grateful to you, Lord.
Just a minute, we can't hear it from like this. You are not studying in grain market.
May I mention the same
Your lordship is coming back in the same combination.
Yes, yes,
There
we
is a
are-
fresh matter at item 50.
No, no, for the time being, we are coming in the same
All
conclusion.
right, great.
Because there are some matters left.
Correct,
So don't get over anxiety, we are coming there.
There is some urgency.
The special bench, I might think of taking up around maybe 3 o'clock.
All right, great.
3:30. अरे 3 o'clock बोल दो अभी तो. We will take
All
up
right,
here.
great.
I'm in item 45, so that matter might not reach. The urgency is the petitioner has to just go abroad for his daughter's wedding. My lords, we have filed an application for permission to go abroad. If my lords can just pick it up after lunch, it won't take.
How many money you have siphoned?
No, my lord, this was a case, there was some dues with regard to Noida Authority, my lords. Earlier also I was.
75 crores are only left. Tell us which your